Welcome back to the channel. As you might have heard from my earlier video today, the Harry case against the Mirror Group newspapers ended yesterday with the King's Counsel for the Mirror Group saying that Prince Harry should receive no more than £500 if indeed he's successful, because it's not quite as simple as that. It never is. So let's take a deeper look at that. Stay tuned. So to look at this in a little bit more detail, we welcome back our guest, Mr. Alan Robert Shaw. And I say guest, but we've got our own channel as well now, Al, which is growing nicely. Thanks to all you guys for subscribing there. So let's take a deeper look at this, Al. So when someone first sent me this, they said, oh, Harry's won, but he's only won £500. But of course, that's not true. No. That is just what's been put to the court to say if he wins, then all he should get is £500, which is a very sort of professional legal way of saying you shouldn't win, but if you do, you shouldn't win very much. So he's certainly not won yet, which a lot of people seem to think he has, because the headlines, bless him, say Prince Harry should get no more than £500. So it suggests to some that he's won and that he should get no more than £500. But it's not quite as simple as that, obviously. He hasn't won yet, has he, Al?
No, he hasn't. I mean, this is very common in law because there are always two elements in any case. There's liability and quantum. Liability is, are you even, responsible? Quantum is, if so, how much should you get? Sometimes we have split trials because only one of those elements is in dispute. Like you might have a car accident where you say, yes, we accept that you needed all this medical treatment and this is what it cost. So, yeah, we accept that is the quantum, but we don't accept this was our fault in the first place. Other times you say, we accept, again, to use a car accident analogy, I accept I bumped into you, but I think you're swinging the lead a little bit there. You could have gone back to work early, and it certainly didn't need that much to repair your car. And you will argue that at the end of the case. You'll say, well, Your Honour, we submit that the claimant hasn't made their case out, so they should get nothing. If, however, you're against me on that and you find that we are at fault, we say the damages should be in this region. So it's a very, very common sort of, approach to litigation here.
So what we've got here is actually King's Counsel for the Mirror Group saying, well, if the court finds that this did happen, and only in this narrow sense, because they're only for this £500 odd, they're not talking about the entire case here. They're talking that they've accepted one instance where they said, okay, we accept that this happened. It shouldn't have happened. It was to do with his a night out in London or something. But if that's what you find, that's all you should find, and you should only get £500. So essentially what they're saying is we're only liable in this narrow sense, and if that's what the court finds, then it's only limited to £500. So essentially they are ring-fencing their liability and saying, if at all liable, it should only be £500, because the detriment, the damages overall that he's alleging in the claim shouldn't be more valuable than £500. But just as a teaser, we will be going into what damages might be available over on Art Media Law with myself and Alan Robert Shaw. Yes, it rhymes. We've got to think of a name that doesn't rhyme, Al. We'll be going into what level of damages may be awarded in proper proved hacking claims over on that channel. You will be directed directly there, hopefully, if we've set this up right, because this should be a live premiere. You should go directly there when this video finishes. If not, you'll find it linked in the description below. So you can find out what real damages would be awarded there. But as we say, a lot of people have thought that this case has concluded in his favour, but there's an argument over the £500. But as I was saying, you can argue either over the liability or the quantum being what is it worth? If you are liable, what is it worth? So I've been to claims before now where we say, our side has said, look, we accept liability, but your quantum is way off, because you're talking about tens of thousands of pounds worth of damage, and we say it was only worth a few £100s. And there's a really silly example of that, actually. There was one case where the guy had his jacket torn, and he was saying it was worth, a couple of £1,000, which, well, first of all, I had issues over why we were accepting liability, because how did a jacket get torn from a very slow parking collision in a car park. But in any event, how was the jacket worth thousands of pounds? It wasn't, and they couldn't prove it. So there we are. But yeah, we wanted to correct that headline. And you were going to go on to say, Al?
Well, yeah, because obviously in this case they've conceded some aspects. They haven't actually. They've conceded that there was a breach, but they're not. They haven't actually conceded that this amounts to something, an actionable claim. They've said yes, this happened. So it's a sort of three-stage test. Well, we accept this happened. We don't accept that that actually amounts to an actionable claim. But if it does amount to an actionable claim, it's £500 tops, and they're still denying everything else. I mean, it's always an interesting thing that way. You concede some points. And there's always this debate as to whether it's better to concede some things. I mean, this is a very common thing in family law. Any family law will tell you, always concede all the provable stuff. Because it just makes you look stupid if you're arguing when there's a definite proof. But then you could go, well, yes, we accept this happened, and this happened. And then when it's put to you and say, we have proof this happened, you say, well, yeah, it did happen. But I suggest all this happened as well. Well, no, it didn't, and that's why you've got no proof. I mean,
and there's a cost element to it as well, because if you spend time, and time equals money, especially in law, I'm afraid to say, but time equals money. So if you spend time and therefore money arguing over something which ultimately the judge throws out, the judge will then say, well, you spent 3 days arguing over this one point that you should never have argued in the first place. And therefore you don't get any costs, or you get penalized for the amount of costs proportionate to that 3 days of arguing over that thing. And that's why we have offers, especially Part 36 offers, which are very, very narrowly defined. And there's been lots of arguments over, does it include interest? Does it include transmission fees and all this sort of stuff? And essentially what that means is that the court's not going to punish a defendant for making a bad offer, but they will punish, for not accepting an offer that should have been accepted, because then you've gone to court and wasted time and obviously therefore money arguing over something that you didn't win and therefore should have accepted the offer in the first place. Or if you don't get a better judgment than the offer was for in the first place, then obviously you should have accepted the offer because it's better than your judgment, and therefore you get penalized for costs. And let's not lose sight of the fact that both sides here will probably be on the hook for, if not many, many hundreds of thousands of pounds, millions of pounds in costs.
Absolutely. I mean, the thing to remember is there are actually a lot more potential claimants. So these are representative claimants, as it actually says on the claim form. So they've from the group they've pulled, and it's interesting, have they pulled sort of a range of strength of claims? Like, you've got quite a weak claim, you've got quite a strong claim, you've got one that falls in the middle, so we can assess all that. How they select who's going to be the claimants. Because in this country, we don't really have sort of class actions like they do in the US. We have something called group litigation orders that sometimes comes up, which is the equivalent of a class action. But they are controlled by the court and the judge. You can't just go out there and say, let's just sign up 10 million people who might have this particular claim. Sorry, no, it's interesting because there's a recent thing where they've just come back. How many claimants can you put on one claim form? And somebody put 3,750 claimants on a claim form, and the first instance court said you can't do that. But what's interesting is the Court of Appeal has said yes, you can. You don't have to do a separate claim form for each claimant. Now, bear in mind that on the box you've got that big to put the names. We're going, do you have to type really small? And they're going, no, you can attach extra sheets.
No, I mean, I had three in one claim the other day, and the court just couldn't be bothered and just put the first party.
Yeah,
but it's the same claim. Obviously, it's identified by the claim number, but there were only three parties, and they just got lazy and just put the one. But no, you're right. So as Al said, we don't have a class action as such. We have a multi-party claim whereby several claimants have got essentially the same claim, or a claim that substantially arises out of the same facts, the same underlying story or facts. So if you've all bought, let's say you've all bought a kitchen and it's all, it claims to be marble, but it's not marble. And there's 1,000 of you that have bought the same kitchen that claimed to have marble tops, and they're not marble tops. Then you could have 1,000, in theory, you can have 1,000 claimants on the same claim form saying, we all bought this from this company. It was supposed to be marble. It wasn't. It's misrepresentation. We relied on it. In fact, it was false. And as a result of that falsehood, we've lost money. We claim the money back. That's the claim. Crash course in misrepresentation for law students, but that's misrep. You could have 1,000 people saying exactly the same thing. this is who we are, this is what we bought, this is what they said, it was wrong, we relied on it. As a result of being wrong, we lost money, we want the money back. Bam, that's it. And 1,000 people could have the same claim. And so what we've got here, representative claimants, I think Al was about to go on to say, are they the strongest claimants, potential claimants, or a mix, as Al said? And it could be. And we don't really know, do we? Because we don't know the full extent of every single claimant, do we?
No, and also we don't know what trial, negotiations and things were, because there will have been preliminary hearings where they selected who the claimants were. I had something once, because another thing that comes in, I won't say what the claim was in case it identifies, but there was a particular claim that a lot of potential people had. They're all quite wealthy, actually. But one of the people who had the claim was eligible for legal aid because they got a qualifying benefit because they're on a pension. So we brought the claim with just that one person, even though if he won, it would affect everybody else. And the Legal Services Commission at the time were going, well, hang on a second, why is it him? Because these are all we know this area, these are all multimillionaires. We go, hey, he's the person who he wants to bring this claim. He's very aggrieved about it and about losing this right of access. And they said, what? And you're telling us that you don't have loads of other multimillionaires in the wings that as soon as they find for him, they're going to jump and issue and say, actually, it all applies to us as well. And that was quite an interesting one because it was actually the Legal Services Commission who, in all fairness, have to keep an eye on the public purse. They were going, we're not sure about this because yes, and they do have a discretion, and they were threatening to say, you know what, we're not going to fund this one because it's clear that all the local millionaires have just picked the one guy who qualifies for legal aid. Because the other great thing about bringing a claim on legal aid is, if you win, you get your costs, albeit they go back to the Legal Services Commission. If you lose, the Legal Services Commission don't pay the other side's costs. I mean, this is why it's a nightmare being sued by somebody on legal aid, because if you lose, you've got to pay the legal aid board back. But if you win, you don't get your costs. Sometimes you'll get what they call a football pools order, which is, okay, I'll make an order that if this person comes into funds in the next few years, then you can chase after them. But that's another reason because like we've always said, it's not about the merits of the case, it's about the costs. And just putting somebody forward in a situation where, look, you're going to have to pay their costs, but you're never going to recover your costs, win or lose. Why don't we just settle this now? And that, it's all about the tactics. And that's why we wanted to put forward somebody who was eligible for legal aid. Now, in this particular case, it'd be interesting because it's very hard to get legal aid now. I mean, pretty much you don't get it in anything except crime and public family matters. So, because they go, look, if you've got a decent case, somebody will insure this. So they let the market decide, which cases make to court. But yeah, so they're representative claimants. The cases will all be dealt with separately. The judge is perfectly entitled to say, I find that your claim, claimants 1, 3, and 5 are successful, but claimants 2 and 4 are unsuccessful. And they will, the judge will then look at each individual case and how much harm has been done. And we'll look on the other channel about all the technical side of things as to how they assess the damages. And also we can look, because don't forget, this is not Mirror Group newspaper's first rodeo. There's already been one round of these cases. So we can actually look at what happened in the previous cases and what offers were made by Mirror Group newspapers, how much the claimants were seeking, and in the end, how much the judge actually gave them.
And on that note, I think what we say is we're going to have to come back and do a full video on a good overview of what has now happened. We did some along the way. The first one that was very popular was over Harry's cross-examination. That was obviously very interesting, but there's been quite a bit happened since then, and I think we've sort of decided to do all those in one. But now we're going to move over to what could potentially be ordered by way of damages if these claims are proven. And for that, if you're on Black Belt Barrister, you should hopefully trip straight over to Art Media Law. Make sure you subscribe there when you do. If not, we'll link it in the description below. And we are going to clip the video now. So thanks for watching so far. And we're going to move over to talk about the technical side of what might actually be issued if these claims are really borne out and upheld by the judge. Because as Al said, it's not the first rodeo. Thanks for watching here on Black Belt Barrister. Make sure you stick with us on Art Media Law. Make sure you subscribe. And we're going to clip the video now. See you soon.